All right, so we're stealing somebody else's PowerPoint. We've stole from Steve Miller a lot. Now we're stealing from Mr. Lippman.
Is that Mr. Miller?
This is his AP Government Chapter 10 on Judiciary. So here we go. Article 3 is the part of the Constitution that is deals with with the judicial branch, and it was meant to be the weakest branch in the Constitution originally. It really is still, even though it has more power than probably a lot of people thought it would have. It's discussed in Hamilton's Federalist Essay number 78. The Judiciary Act of 1789 established the court system as we know it today, a three-tier system with the Supreme Court, Courts of Appeal, and district courts. And there's at least one district court in every state. So this shows the boundaries of federal district courts and courts of appeals. You can see that Oklahoma is part of the 10th Circuit. And that includes Kansas, Nebraska, Colorado, New Mexico, Utah, Wyoming. And you see the breakdown of the 12 circuits of the courts of appeals, circuit courts. Sometimes courts of appeals are called circuit courts. And within each of those circuits, there's also various districts. So you see the Ninth Circuit that has basically the West Coast and Alaska and Hawaii in it. Jurisdiction, a three-tier system. The court that has original jurisdiction in most cases is a district court. There are 94 of them. In the courts of appeals, there's really 12 if you count the one in Washington, D.C. The patent court, state court systems. So when this slide's talking about jurisdiction, who handles original jurisdiction in most cases? You have these specialized courts. You have the state courts, of course, for state laws, and you have the district courts for most original jurisdiction. There are some things that the Supreme Court has original jurisdiction on. And this shows how the American judicial system is structured. And it's fairly complicated. Probably what you should do if you watch this on YouTube is stop this and just stare at it and read it. You see the state court systems with state trial courts. There are 100 million filings per year. State intermediate appellate courts found in 39 states. So 39 states have state intermediate appellate courts, which handle 300,000 cases per year. The highest state courts, 52 courts, handling 95,000 cases per year. Oklahoma is one of those weird states that has two Supreme Courts, breaks it up. U.S. District Courts, 94 courts handling 350,000 cases per year. So look at that, 100 million filings in state trial courts, 350,000 cases in U.S. District Courts. So significantly less litigation going on at the federal level. So cases heard in the U.S. District Courts. Federal government is a party, civil suits under federal law, civil suits between citizens of different states if the amount at issue is more than $75,000, admiralty or maritime disputes, bankruptcy, other matters assigned to them by Congress. What does the courts of appeal handle? And they handle 60,000 cases per year, which out of 350,000 district cases and some other cases, you have 60,000 cases that are appealed. They have no original jurisdiction. The U.S. Courts of Appeals do not handle anything for the first time. It's gone from either the district courts or it's gone through regulatory commissions or the legislative courts, including the U.S. Court of Federal Claims and the U.S. Court of Veterans Appeals. And then, out of those 60,000 cases appealed there, the U.S. Supreme Court hears very few of them because the U.S. Supreme Court hears only about 75 to 90 cases per term, per year. The Supreme Court rarely exercises its original jurisdiction. Only 1 to 3% of the cases the Supreme Court hears is original jurisdiction. Cases that are heard by the Supreme Court first are cases that involve two or more states, the United States and a state, foreign ambassadors, other diplomats, and a state and a citizen of another state if the action is begun by the state. Most cases heard by the Supreme Court are under its appellate jurisdiction. 97 to 99% of its cases. The Supreme Court can agree to hear cases involving appeals from the U.S. Court of Appeals, the highest state courts, but only if they involve federal questions, and the Court of Military Appeals. Key justices. John Jay was the first Supreme Court Chief Justice. He handled the Chisholm versus Georgia lawsuit. His decision led to the 11th Amendment prohibiting suits against states in the federal court. He felt the job was so weak that he left to be the governor of New York. Originally, there were 6 Supreme Court justices. The number would fluctuate, but in 1869, it was set at 9 and has remained that way since then, but it could be changed by Congress. The Marshall Court. Marbury versus Madison and judicial review is the legacy of one of the legacies of the Marshall Court. The Marshall Court is the court where John Marshall was the Chief Justice, and he's pretty much the one who shaped the way we view the Supreme Court. Marbury versus Madison. Through the necessary and proper clause and national supremacy, established judicial review. That's the issue where part of the issue was a political question. Marbury was suing Madison because Madison did not deliver the papers that would have allowed Marbury to be a federal judge. And although Marshall would have preferred Marbury to become a judge, he ruled that it was not a decision that the courts should make, that it was more of a political decision between the outgoing president and the new president, Jefferson, because Madison was in his cabinet, but they reserved the right to review things as far as what their constitutionality was. So it established the precedent of judicial review. McCulloch versus Maryland established the principle of national supremacy, citing the Supremacy Clause, and it also created a broad interpretation of the Commerce Clause. McCulloch versus Maryland had to do with the National Bank and whether the state of Maryland could tax the National Bank. And the court decided that no, the Supremacy Clause means that federal laws are supreme in areas where they conflict with states. As long as they're constitutional, they're supreme. And it argued that the power to tax is the power to destroy, so you can't give the state that kind of power over federal institutions. So John Marshall, Chief Justice from basically 1801 to 1835, had the greatest impact. He was a Federalist, and even after the Federalist Party had faded away, and the Democratic Republicans were dominating completely, especially during the era of good feelings, he was still there. And he had a big hand in Marbury versus Madison, which is about judicial review, McCulloch versus Maryland, which is about national supremacy, and Gibbons versus Ogden, which is about the Commerce Clause. Okay, and Gibbons versus Ogden greatly explained how broad the Commerce Clause is and how it works when state commercial laws and federal commercial laws conflict, and that's the one about the steamboats. And the state, New York had given a monopoly to, I think, Gibbons. Maybe it was Ogden. And the point is a state monopoly on steamboats traveling from one state to the other violates the federal power over interstate commerce. Other justices of some fame. Justice Taney or Taney, depending on who you talk to. He's the guy who did the Dred Scott decision, which helped cause the Civil War to have to happen. Justice Holmes, First Amendment, his explanation of the First Amendment and how important the First Amendment is. Justice O'Connor is the first woman as a Supreme Court justice, the first African American, Thurgood Marshall. Justice Rehnquist, who limited executive privilege and was a conservative Chief Justice. Justice Warren, who emphasized the rights of the accused. He was the Chief Justice when Brown versus Board was decided, and he was in charge of the most liberal and activist court we've had in some time. Justice Roberts is the present Chief Justice. So can Americans name the justices of the Supreme Court? This is a poll from 2010. 19% knew who Clarence Thomas was because of the accusations made against him by Anita Hill, who was a law professor at OU. But when at one point she worked with him, I believe it was OBU, or maybe it was Oral Roberts University, I can't remember which. And she claimed he was sexually harassing her. John Roberts, Chief Justice, Sonia Sotomayor, 15%, Ginsburg, 13%, Scalia, 10%, etc. People don't know who's on the Supreme Court. There's been some change. The present Supreme Court, let's look at this. Roberts, appointed 2005. Scalia, Kennedy, Thomas, Ginsburg, Breyer, Alito, Sotomayor, Kagan. We have 3 women on the Supreme Court. That's a fairly new development. Pretty cool. And if you look at who appointed them, you get a sense of maybe their politics here. We've got a George W. Bush, 2 George W. Bush appointments, 1 Bush appointment, so Bush 41, 2 Bush 43, 2 Reagan, 2 Clinton, and 2 Obama. So you have 4 that have been appointed by Democrats, you have 5 that are appointed by Republicans. Key terms to know when it comes to the judiciary branch. Precedent, that is, and stare decisis, they're related. The idea that a judge should look at decisions previous judges had made over the same issue to guide the decision they make. Stare decisis literally means let the decision stand. And the decision that you let stand is the precedent. Senatorial courtesy, the power of a senator of the president's party to help control who gets to be in district court in the state that he represents. Writ of certiorari, what the Supreme Court has to issue in order for them to consider a constitutional question in a case from a lower court. The rule of 4, how many Supreme Court justices have to agree to consider a case? Amicus curiae means friend of the court. This has come up several times when we've talked about civil rights and civil liberties, when we've talked about the judicial branch, and also when we talked about interest groups, because a lot of amicus curiae, friend of the court briefs, are written by interest groups. Solicitor General, that's the attorney in the Department of Justice that represents the government's interest before the courts. So they're the attorney for the federal government before the Supreme Court justices when they hear an issue that involves the federal government directly. And there you go. First Monday in October. I believe that has something to do with when cases start being heard. I sincerely doubt that ever appear on AP exam. Majority opinion. The opinion that the majority of the Supreme Court hold, that becomes basically the law, if you will. It becomes precedent, a decision that other justices and judges are going to follow. Concurring opinion. When a judge agrees with the decision the majority makes for a different reason than they have. Dissenting opinion. When a justice in the Supreme Court disagrees with the decision the majority makes. Like that one guy who disagreed with the Plessy versus Ferguson decision on separate but equal. Doctrine of judicial restraint, the idea that the courts should only deal with very strict issues that are very easy to see being applicable to what the Supreme Court should do, and making decisions based on the wording of the Constitution closely following the letter of the law. Doctrine of judicial activism, the idea that you can use the Constitution to see some basic general principles that you can follow through with further on, even if they're not expressly stated in the Constitution. For example, if you are extremely involved in judicial restraint, you would argue that there is no right of privacy. If you have some kind of leaning toward judicial activism, you would argue that because of the Fourth Amendment protections against search and seizure and a couple of other amendment issues like the Quartering Act, well, not the Quartering Act, but the Quartering Amendment, that there is an implied right to privacy already in the amendments and already in the Constitution, and so you can derive from that, even though that is not expressly stated in the Constitution, through judicial activism, you can say that there is a right to privacy. You can go to the Ninth Amendment, the one that says that just because we forgot to write down a right doesn't mean it doesn't exist, as justification for judicial activism. Doctrine of judicial implementation. How do you implement a decision, and what do you do? Things like that, which your book didn't really get into. So we'll move on. So in criminal trials, the blank are the plaintiffs, while in civil trials the blank are the plaintiff, and this is a multiple choice thing. And what they're saying here is, in criminal trials, the government is the plaintiff, and while in civil trials, there's a lot of actual variety. It could be private individuals, it could be groups, it could be the government too. Stare decisis literally means what? Let the decision stand. How federal court judges are selected, the confirmation process. They investigate, they look into the justices. They ask the American Bar Association what their opinion is of the justice. There's lobbying by interest groups. This caused problems for Bork, but Christian organizations supported him. Pro-choice organizations didn't like him. You have Senate committee hearings and a vote, and they become more intense and more partisan and more argumentative since the 1980s. Appointments to the Supreme Court are important because those justices last a long time, but it's also unpredictable. It's difficult to tell when and who's going to get. The term is borked. Bork was someone who didn't get to be a Supreme Court justice. So who opposed Robert Bork's appointment to the Supreme Court? Liberals. The Supreme Court today, deciding to hear a case. Supreme Court hears approximately 1% of cases filed. The Supreme Court issues a writ of certiorari to hear the case. The rule of 4, at least 4 justices must sign on to a writ of certiorari. Role of clerks, initial filtration process. Clerks look through issues and look for things they think the justice might be interested in. So chances are your case, if you try to appeal to the Supreme Court, probably won't get past a clerk. So what does amicus curiae literally mean? Friend of the court. A strict constructionist believes in a what kind of constitution? Dead constitution. You can't change it through interpretation. You can't change it through finding some truths and add to it through deduction or induction. Analyzing values, race, gender, and ethnicity of federal court appointees. And you can kind of stop this on YouTube and look at it if you choose. How many cases does the Supreme Court handle? Cases filed versus cases decided. The little mark at the bottom is the cases they actually decide. Very few. 125, 150, 158, 152, 147, 87, 82. You get the idea.